Good morning to everybody here. First of all, to the International Disability Alliance, you state that Ireland's one of three EU countries that haven't ratified the optional protocol. Have the other states ratified the convention but not the protocol? Because I'm presuming most countries ratify both together. And on that, I suppose just a comment, I can't understand why there is an optional protocol at all, why the whole lot hasn't just been as one part. You know that it doesn't make sense that you ratify a convention and then don't ratify the optional protocol with it. Also, on the procedure of inquiry, is it true a country can opt out of that they can't opt out of the individual communications, but they can opt out of the procedure of inquiry? And if so, I'm hoping that this state won't do that, but I'm fearful that they will. And just to follow on from one of Mary's questions there, she was saying that before you can take a case under the convention, you must exhaust national inquiries or complaints procedures. And you said if you can show or prove that they are not going to give you a result, you can go straight to the convention. But how do you actually show or prove that the national complaints procedure won't work in that case? And then for the Decision Support Service, wards of court, you said are to be discharged under Part 6. In order to do that, you have to have access to legal aid. Will free legal aid be available to people in that instance? Also, I'm aware of someone who was made a ward of court just last Friday. I mean, I'm just wondering why that procedure is still being adhered to when we're about to come out of it. I mean, it doesn't make much sense, and it's caused a lot of upset for the family in question. And just maybe around that, I mean, you were saying that you assume, or people will be assumed to have capacity. So how is it, or whose responsibility is it to I suppose, check if they have capacity or not? You know, I mean, is the procedure going to be different to the current procedure in determining whether somebody has capacity or not? Thank you.
Thank you for the question. So as to why the communication procedure is not within the CRPD itself, I don't have a good answer for you. In some treaties, in some human rights treaties, it is done that way, and others it is integrated, and so there's a mix of practice. It's roughly 2/3 or so of, well, actually 100 out of 184 of states parties to the convention have ratified the optional protocol, so that gives you a sense of the number. In many cases, it's years later after states have considered, seen the results of the views of the CRPD committee, and perhaps want to reflect whether that is something they are willing to have their scrutiny placed upon them. So there's a real range of approaches. It is also true, as you say, that one cannot opt out of the inquiry procedure. Of course, that's not something that we would recommend. The inquiry procedure is not often used, and one can't quite know if it will be applied to Ireland. My sense would be possibly not, but there's the example of the United Kingdom was one of the first inquiries, so that may give you some interesting insights. Yeah, so it's there are a range of options, and of course we would always encourage the most progressive and human rights friendly approach.
For us. Thanks, Deputy. And your first question concerned the review of those existing wards of court under Part 6 of the Act. And I think the first was a practical one about legal aid. I'm not able to locate the actual amendment at the moment, but I am confident that an amendment contained in the amendment bill does extend the provision of legal aid to those wards who will have access to the discharge process under Part 6. The position of, as I said in the opening statement, the position of wards of court is improved by amendments to Part 6 generally in terms of representation, access to the court to have their voices heard, and the removal, the entire repeal of a section, I think it was 57, which proposed an abbreviated process for current wards of court, and which referred to a class of wards, which I think was objectionable language, and that has been repealed entirely. Your second question then was about why are people still being admitted to wardship at this late stage. The DSS isn't party to those applications. Indeed, we won't be a party as such to Part 6 either. Wardship should currently only ever be applied for as a last resort. It's an archaic process and its repeal is certainly overdue. I suppose petitions are brought because there's a perception of a particular need, a decision or set of decisions that need to be taken and that the support of wardship is required. So I know nothing about the case, obviously, to which you refer, but I presume it was in those particular exigencies that the application was brought. But you're quite right. The person who has been admitted to wardship will immediately be eligible to apply to come back out of wardship.
How long will that take? Because you're saying there's 2,200 people currently in wardship. So, and we know our legal system isn't robust. It's very slow. So how long is it envisaged if all of them apply?
Yeah. Again, questions probably better addressed to the courts service who have been mobilising to prepare for these applications under Part 6, and I know that they have done preparatory work, including actually engaging with existing wards of court, their families and their committees, and they've done a communications exercise around that. From information that I heard yesterday, about 40% of the current wards of court are anxious not to wait and would ideally like to see their applications heard and to be discharged from wardship within the first year. I don't have any particular intelligence as to how long it will take or how the court is organising for that. I certainly had heard that perhaps 3 judges were going to be identified to take rolling lists to deal with those applications, whilst another would deal with continuing orders in wardship. But really those questions, I suppose, are better addressed to the courts service.
Just the reason I asked about the legal aid is I know, say, if someone is taking a case under the Equality Acts and they're taken to the WRC, you can't use the free legal aid service in that. So I'm just wondering if it was different for...
And I should say, actually, the idea of these amendments to Part 6 had been to create parity between those current wards of court and the relevant person, so-called, under Part 5 of the Act, who would be the subject of an application under Part 5, the new procedure with that court process. And they will have access to a scheme of legal aid. It isn't means tested. They don't have to satisfy the criteria that might ordinarily apply to show chances of success or risk-benefit analysis. So it is a fairly accessible scheme of legal aid. It is to be hoped, but again, the Legal Aid Board might have better information on that.
Okay, thank you.
Sorry, your second question was about the presumption of capacity, which is the law already, actually. It is the common law position. It should apply even in wardship, that an adult is presumed to have capacity. So the Act is simply putting on a statutory basis what is already the position, so that if there shouldn't be any kind of transformative aspect to that, because it really should be happening already. And the functional assessment, and I know there's some contention around the propriety of a functional assessment of capacity, we could speak about that for quite a while, is already the law also, and has been. It was the common law position. It has been for the last 14 years, since 2008, and is already operating and adopted in policy and standards documents. So again, very much with us already.